So the first question is, what if the tribe finds out that the qualified expert witness did not interview family, but merely reads reports and makes an opinion? What can be done?
That's a great question. If the tribe is participating in the case, then what can be done is to object to the witness serving as a qualified expert witness. So basically, the tribe, either through their legal representation or through whoever is designated to represent them in the court proceedings, can object to the witness's qualifications. So the tribe can say that witness didn't do the proper research in order to form an opinion, and therefore we object to them being qualified as an expert witness. So before they even get to the testimony about whether or not the placement is correct, the tribe can object and say this person hasn't met the minimum qualifications for being an expert. I will warn you that argument isn't always going to be successful, but I think that it should be considered by the tribe as a valid argument. And hopefully the court will see that it takes more than just reviewing the agency's reports, because that's all information that obviously the agency believes they're putting it in their reports. And it's the duty of the expert to go beyond that and sort of do an independent support or corroboration of what the agency's already putting out to the court. So I would say object.
And Christine, I'm going to jump in because as I was reading this, I could see it being interpreted, the question being interpreted two ways. One is, what do you do if the other side's expert didn't read the reports? If you're the tribe and you actually hired this qualified expert witness and you find out they didn't do their research, that's where the contract comes in. That's where you say the duties of the expert witness is to do the research. So that's another reason why you want to have the contract, not just for the qualified expert witness, but also for the tribe, to make sure that the person you're paying or asking to do this, and even if you're not paying them, it's in lieu of their business, but if they sign the contract so it's understood that they are being required to interview, and if not, do best efforts to interview and document why they didn't interview. Anything else to add, Christine?
No, I would just say that even though you're hiring someone to serve in this sort of professional capacity as this expert witness, I would not trust that that person is going to meet your expectations unless you lay them out very clearly. And I recommend the best way to do that is in writing through a contract. So just state very plainly what you expect from the expert that you're going to attempt to use in court. And I think that gives you the best result in the end.
Okay, so did that answer that question?
Anything else?
Okay, I'm not seeing anybody shaking their head no. So the second question we had, Christine, was what if you have provided a qualified expert witness, or you have provided qualified expert witness testimony in the past for free? Can you now ask for retro payments?
Ooh. Well, I'm a lawyer, so I think you can ask for anything. I don't know if you'll get it, but I think it never hurts to ask, right? So you definitely could approach it, but I would say certainly going forward, you would want to, talk to, if you're being contacted by the same agency or person that had asked you to provide testimony in the past, you might tell them, I'm now going to have to be charging for my services as an expert witness. And so, I hate to shock you, but that's the terms that I'm going to agree to. So, I mean, there's nothing in the law that sets out what compensation is appropriate, and no one's necessarily entitled. But I just put in the compensation piece because I do think everybody's time is valuable. So.
All right. Do we have?
So go ahead and ask. Ask for it. Why not?
I'm just going to point out the last question was met with great support of, yeah, that's a good question.
Certainly there's more important things going on in all of these cases than money and compensation. But I do feel like there's been in the past, and maybe historically, a sense that if the person isn't someone with a professional degree, then there's really no reason to compensate that person. And I just personally take issue with that because I feel that everyone's time is really valuable. And while I definitely value education and law school is something I'm proud that I was able to complete, I have gained a lot of knowledge from people who don't have any kind of higher education or degree. And so I think knowledge can come in a lot of different forms. And I think if someone's providing their time and their knowledge, it's definitely appropriate to offer to compensate that person. And if you are that person, to ask to be compensated. So that's my only point is I do feel that dominant society tends to maybe overvalue education and devalue customary knowledge, which, you know, there's some things you can't learn in a book. So I just want to just emphasize that. It's not about money. It's really more about where we place value and making sure that, you know, dominant culture understands that there are some things that you just can't learn in a book, but they're incredibly valuable. So, so now that I've made that sort of disclaimer, I, based on a question actually that Stephanie posed earlier about the qualified expert witness not being someone from the agency, I just wanted to go back and clarify. While I think that started maybe in case law, it definitely was put into California law when Cal ICWA was passed. So you can find that in the Welfare and Institutions Code, section 224.6. And during the break, I made a new slide here. This is the list from Welfare and Institutions Code 224.6A that states that a qualified expert witness may include, but is not limited to, social worker, sociologist, physician, psychologist, traditional tribal therapist and healer, tribal spiritual leader, tribal historian, or tribal elder. So that's the list. And then on to what was also of critical importance, it clearly states in Welfare and Institutions Code 224.6A, the very next phrase is, it cannot be an employee of the person or agency seeking foster care placement. So we definitely have gone beyond case law and can find this now in the Welfare and Institutions Code. So I just wanted to be clear on that before we moved on to the next part of our presentation. I did want to talk about the qualified expert witness and agency conflict. So if the agency, meaning the county child welfare department, county social services, county health and human services, whatever the name is, if the county agency has contacted the qualified expert witness and asked them to, you know, provide the expert witness testimony in its particular case, and hopefully there has been a contract that has been entered into and signed in writing. But either way, the county has retained this person. The qualified expert witness has a duty to be honest. So the qualified expert witness has been retained to review and investigate the case information and then form an informed opinion based on their review of the documents and based on any interviews they may have conducted. Given that, there is no guarantee that the qualified expert witness's opinion is going to support the agency recommendation. So it could be that after conducting a review and research into the case, that the person who has been retained to provide the testimony doesn't agree with what the agency is recommending to the court. So what happens when that has come up? And just wondering if anybody wants to share by show of hands. Has that come up for anyone ever? Just wondering.
So the question to the room is, have you ever been in a situation where you're serving as a qualified expert witness or you're dealing with a case where the qualified expert witness's opinion does not agree with the agency that hired them? I got a show of hands. Got a couple shows of hands. All right.
Okay.
And Christine, I assume there could also be a situation where if the tribe has a qualified expert witness to counter the agency and the expert witness doesn't agree with the tribe that hired them, that could also be a situation? Or am I just,
Yes.
yeah, okay.
Okay, so given that, I mean, to me, that has to be an outcome in some cases if everyone is being honest. Because, you know, not everyone is going to agree all the time. And so the expert is, you know, likely on occasion to review the file and come up with a different opinion than what the agency is recommending. So I think that to start, you should really pin down what are the specifics of the conflict. The qualified expert witness should state why they cannot support the agency recommendation very clearly. And again, preferably, I think this should be done in writing. Was there something culturally that the agency didn't know or that the agency failed to consider? For an example, I just used this example, and there could be very many of these, but maybe the qualified expert witness states that they cannot support whatever it is, the recommendation of the agency, if it's for foster care placement or termination of parental rights, because no services have been provided to correct X behavior. And if services were provided and failed, then the qualified expert witness might change their opinion. So that's something that I've heard expert witnesses have a conflict with in the past, which is where, you know, I'm using that. But it could be anything. The expert witness could just, you know, find something in the case that the agency felt justified a foster care placement, and the qualified expert witness felt, well, no, that's actually culturally appropriate behavior for this child's tribe, and it would not justify removing the child and placing them in foster care or terminating parental rights. So, again, the importance here is pin down what is the problem, where is the disagreement, where is the conflict, and is it something that maybe could be corrected if the agency got more information. If the agency gets the new information from the expert and decides they're going to proceed with their recommendation, even after the conflict has been specified and identified, then the agency will need to secure a new expert, and they should specifically address the concerns of the original expert. You know, I'm not sure how often that's happening in cases when conflicts come up, but it really should be that the new expert is going to directly address whatever those specific concerns were that the first person that was contacted to be the expert had that kept them from providing the testimony. And unfortunately, this may lead to a battle on the witness stand with two conflicting testimonies from two different experts. And as someone who's had to experience this in court, it is not fun. However, sometimes it's necessary because, like I said, people can disagree. So you may have a case where there are two people that are both qualified as expert witnesses, both testifying to exact opposite positions about what the agency is recommending in the case. That is called the battle of the experts. And it happens in other cases as well, not just in Indian Child Welfare Act cases. There's another way that battle of the experts can occur, and that's when the agency is putting forward an expert that is supporting their position, and the tribe then provides another expert that is going to say something to the contrary. And so they're, you know, just because the agency has an expert, and someone asked me this before, what if the tribe doesn't feel that the expert has done the research required? Or what if the tribe doesn't feel that the expert has the knowledge they need to testify in this case? Whatever it is that the tribe, or any other party for that matter, doesn't agree with, they are entitled to bring their own expert to provide testimony in the case that contradicts what the agency's expert is saying. At that point, the two experts will both provide testimony, and then it will be up to the court and the judge to hear from both experts and decide which testimony is going to be more compelling and which testimony they'll follow in court. I will say that if you find yourself in a case where you're going to be dealing with two different expert opinions and battling of the experts, if you have access to legal services, this is a really good time to use that resource. The testimony is going to go probably from a less formal to a more formal level at that point. There'll probably be more objections, and this is when it really helps to have a lawyer in the court to help you in your position. And the agency will always have county counsel there, so it's really more for tribes, because as the tribe, you can intervene in the case and you can become a party, but you'll be the only party there who's not entitled to court paid for or court appointed counsel. So if you do have any resources or any way to access legal counsel, this would be sort of the minimum area I would want to recommend that you go ahead and use that resource. Although, lawyers are always helpful, I will say that. Well, so testimony in court. So the qualified expert witness takes the witness stand and they're going to testify in court under oath. I think it's critical that you inform your potential expert witness in advance that they are going to have to be present in court and that they are going to have to testify to who they are, what they've done to prepare, what they know about the case in court under oath, so that no one is caught off guard, because the expert that they may be the perfect person in terms of their knowledge and their expertise, but they may feel unable to come into court and testify in front of other people and then be asked questions, potentially by 5 different lawyers. So after you've made that very clear and the expert witness feels they can at least come into court and provide that testimony, then you go into the qualifying of the expert. So this is where the direct examination, the cross-examination, and potentially even the redirect examination is going to come into play. And we'll go through what each of those are in the following slides. Okay, so qualifying the expert. This is an actual, legal procedure that happens on the stand where the expert who's being asked to provide their opinion needs to establish or qualify that they do have the requisite knowledge, the required knowledge, to go ahead and provide testimony on this case. So it's going to start with questions from the same side's attorney or representative to establish that this person is qualified to provide the testimony. And when I say the same side, I mean if the testimony is being provided to support the tribe's position, then whoever is representing the tribe would start by asking questions of the expert witness. If the witness is there supporting the agency's position, meaning the county, then it would be the county's attorney who would start by asking questions to qualify this person that they are, in fact, able to serve as this expert, that they have the knowledge to serve as an expert. So these are some questions that are sort of the minimum questions that should really be included in any testimony to qualify someone as a qualified expert witness. And first, obviously, you're going to want to identify the qualified expert witness by asking, what is your name? And, that one is pretty obvious. Then you're going to want to move into, what is your occupation? What is your education and training? What practical experience do you have relating to the matter that you'll testify about? What research did you do to inform your opinion? And then finally, what opinion did you reach? So the practical experience can be anything from being a member of the child's tribe, being a member of another tribe, having lived in the community, worked in the community that the child is a member of. Those are the kind of things that you want to talk about in terms of practical experience. But you also want to, excuse me, you also want to make sure you talk about if you have any specific knowledge about child rearing standards for this particular tribe. And that, I think, in my opinion, that is the most kind of qualified person you can have for a qualified expert witness, someone with experience and knowledge about the child's tribal customs and traditions around child rearing. And then the research, meaning did you do all of those things that we talked about for preparing? Did you review documents? Did you review service logs? Did you interview anyone? Hopefully there's someone there that can ask you all of these questions if you are the qualified expert witness, so that you're not having to just sort of talk in a narrative and remember everything yourself. Although you can write out what you want to say and use that as a script if it helps you in court. And then finally, the opinion that you reached is going to be that very specific language about the emotional or physical harm to the child. So then next, after you've been had gone through a direct examination where you've been asked very direct questions, who are you? What's your name? Where do you work? Are you a member of a tribe? What did you do to prepare for the case? Then you'll move into cross-examination. And here, the opposing side, so that's whoever's on the opposite side of who has retained this person to be the qualified expert witness, they get a chance now to question the qualified expert witness in court. And at this point, I guess the witness really isn't a qualified expert witness yet. They are a potential qualified expert witness. So the opposing side is going to have the chance to challenge the qualifications of the qualified expert witness, anything from the education, the training, the work experience, the life experience, the practical experience, anything that is presented in that direct examination that qualifies the person to provide the testimony. This is the chance for the other side to challenge that in open court. And so that was, again, we had that question earlier, as to the preparation. What if you don't agree? Then you can challenge that preparation in court. You can make statements saying this person shouldn't be qualified as an expert because they did not prepare enough. They did not do any independent interviews with anyone. All they did was read the same reports that the county filed in the court and haven't talked to anyone else about it. Cross-examination can also cover the allegations of bias in the outcome of the case. So I have heard from other attorneys that some county agencies have been using the same expert witness over and over in many cases. And while that isn't necessarily a bad thing, it certainly could lead to someone on cross-examination alleging that that person is biased. They're basically, an employee of the county, and they come in on every case, whether they're knowledgeable about that specific tribe or not, and they always support the county over and over, and they've never disagreed with the county, and they've never provided testimony for any other side. So if the opposing side suspects that there is any bias at all with the expert witness, this is where they could allege that that bias is on the cross-examination. You cannot typically go beyond what was covered in the direct examination. So if an area just wasn't touched on at all, then you shouldn't be allowed to go past that. And I think that's where it helps to have someone there to sort of, quote unquote, protect the person who is trying to be qualified as this expert witness. Because if someone starts asking a line of questions that either wasn't covered in direct at all or is just irrelevant, and it's really just meant to make the person on the stand uncomfortable, this is another place where you can object and say to the court, this was not covered in the direct examination. It has no bearing on whether or not this person is qualified to provide this testimony, and this line of questioning should be stopped by the court and shouldn't continue. So that's where you want to have that protection. And again, that's where it really helps if you have either an attorney or a separate representative that can, speak to the court when it's happening and isn't there on the stand providing the actual testimony. And then finally is redirect. And redirect is really just when the party that's trying to use this expert to support their side gets to respond to anything that happened on the cross-examination. It's usually there to clarify any remaining questions that may be for the court, or again, go back and address anything that was brought up on cross-examination. And something that, for example, I've used in redirect is, someone will maybe on cross-examination attack the fact that my expert witness that I'm trying to provide doesn't have any kind of formal education. On redirect, I can come back and say, you don't have any formal education. However, can you talk about how long it is that you have been, teaching classes on parenting at the tribe? And so that's a way to come back and redirect and sort of make, your point after the cross-examination has happened. Let's see, what's next? Before we move to any best practices, are there any questions about the testimony part and what's going to happen when you're on the stand or when your expert witness is on the stand?
Okay, you brought up something about relevancy, and so I'm making a list of people who I see as a potential expert witness in my area, and having been a social worker and been on the stand, I understand that they can ask you some pretty good questions that can get under your skin sometimes. Not necessarily badgering, but just sometimes you might lose your cool. So if I'm an ADAC counselor, or if I'm a counselor who's doing parenting classes, or I've been child molested, and the case is about child molest, or it's about alcoholism, or how do you protect that expert witness that my history as an expert witness isn't thrown back into my face?
So some of the question was difficult to hear, but I think, and let me know if this is an accurate sort of summary of the question, was how do you deal with very sensitive issues that may add to a witness's qualifications in a case, but are difficult to discuss on the stand? Is that accurate?
Well, not necessarily difficult to talk about, because if I'm a counselor, I'm assuming that I took care of my difficulties a long time ago. Otherwise, I don't have any business being a counselor. But when you're in that push-pull of a parent, and we all know, we all come from Indian communities, right? Most of us. And we know our Indian communities, so we know who got picked up for drunk driving 20 years ago, or we know who has skeletons in the closet. So if I'm the expert witness and I'm over here talking as an expert witness saying that, no, this child shouldn't be returned to this family because there's a long history of alcohol and drug abuse, and they say, hey, she got picked up 20 years ago for a DUI. She lost her kids for 4 years before she got them back. Okay. Have I opened up the door because I'm the expert? Is my history going to be challenged? Or, if I don't have a good lawyer to say, hey, inappropriate question, I'm the one that asked the question about personal questions and expert witnesses not wanting to be on the stand, because I think that's something that we are pretty aware of as to why we lose our expert witnesses, or why we don't and can't keep them. Because it only takes one time on the stand to say, crap, I don't want to do that again. Money or no money.
So Christine, did you get the question this time?
Yes. And I mean, the short answer is yes. I think that if you, as part of your testimony, are stating your opinion based on information that you have from just, living in a community with someone, knowing their past history and possible past indiscretions, and that's what you're relying on as part of your opinion, then I think you are opening that up to cross-examination. So, what I would recommend is if you don't want to take, that kind of a risk of being on the stand and opening up this person's history far beyond what social services may, know. If you don't feel like that's something you want to do, or that's not in the best interest of the case, then, you can not provide the expert witness testimony. Otherwise, you can make sure that what you're speaking to and what is in your written report or declaration is only based on what's happened, in this case. But again, it's difficult to separate what you're learning just through your research on this case based on interviews around, the very incidents we're talking about for this case, and your community knowledge and, growing up with someone in their community and knowing them, who they are. But the short answer is, yeah, anything that you rely on for your testimony, it can be discussed on direct examination or cross-examination.
Yeah, let's get you on the mic.
And I think that's going to be challenging in a lot of cases.
Christine,
You've got a comment?
this is my take on this, Mark. I think as the order of proof goes, normally you will see the qualification of the expert come before you will find their substantive testimony. So those issues will have to, by necessity, have to be resolved first. Then, if there is an issue about bias, there's always a question whether a witness is biased. But once an expert is qualified and you move on to the question of their opinion, that's going to be based on fixed information. And if someone wants to go back in time and raise another issue about bias or qualifications, I think the objection is that it's more prejudicial than probative. And I think the expert themselves could make that objection. But I don't see a hodgepodging of the two parts, at least in my experience. Once you're qualified, the court's not going to waste the time to go back and see if there's any skeletons, unless they were in the report, unless you put that in. But bias is always an issue. I think that's fair game.
Okay. And we've got additional question pertaining to that or comment.
Now, let me clarify. It's not the skeletons in the closets of the people I'm researching. It's the skeletons in the closet, in my closet. Too late. Too late. I mean, we all know people who have gone back, sobered up, gone back and got their education, and they're working in the field. It's common, and, they have the passion, and they want to help, but it only takes one time to lose them.
So can I just recap your question and what I think the appropriate response is, Christine, if that's okay? So
Yes.
The question is basically, how do you protect witnesses? How do you maintain tribal members to be qualified expert witnesses when there is a possibility that them going on the stand and using their experience in the community, their experience as members of the tribe, their experience with working with people within the community and knowing community members, that experience not only gives them the ability to be the expert, it's relevant to their expert ability, but it also, as Christine pointed out, opens them up in cross-examination to their skeletons in their closet. So when they're being qualified as an expert, they might not have mentioned, I'm basing my opinion on the fact that the family's known for alcohol abuse, and even with remedial actions, they haven't changed their pace. And then your qualification, they bring up, you had an alcohol abuse issue. So I think what Christine's trying to say is there are ways to combat that, but it's going to come up. And preparing your witness for the possibility that you will need to address the fact that you have a history. And preparing your expert witness is the best you can do. And what Mark's pointing out is you may be able to sometimes prevent that line of questioning if it, one, doesn't pertain to the basis of how you came up with your opinion. If you are not basing your opinion on the fact that you know that their family was using alcohol or alcohol abuse has nothing to do with the forming of your opinion, your experience with alcohol abuse, if it didn't pertain to how you came up with your knowledge and your expert opinion, shouldn't be part of the cross-examination because it wasn't your basis for coming up with your opinion. The questions at cross-examination are not about your history and who you are as a person unless you rely on that in forming your opinion. Does that make sense, Christine?
Yes, it does.
Now, if your history, whatever it may be, is what you're relying on, or your experience in the community is what you're relying on, you're saying, well, I've been a member of the community and I know X, Y, and Z about these people as a result, that means everything about your history can be opened up as a part of it. So part of it might be if you have an expert witness who has a lot of skeletons in their closet and they've dealt with them and that's qualified them to be an expert now, they're going to need more preparation going on the stand to be prepared that if they're relying on their experience in the community and the fact that they've been in the community, that's going to open them up to even more possibility for cross-examination where their skeletons get brought up. But if it isn't directly connected to how they form their opinion in this particular case, then there's a very good objection to it's irrelevant, it's not the basis of their opinion, and those questions need to be stopped. If you don't have an attorney, which is the other thing Christine pointed out, if you don't have an attorney there, that's something that either the social worker or the expert witness needs to be prepared to say, I don't see how that's relevant, objection, I don't see how that's relevant, or my history, whether it be what you're saying or not, is not how I came up with this opinion. Or that part of my history, whether true or not, was not part of my opinion. Is anything I just said inaccurate, Christine?
No, that all sounds perfectly accurate to me.
So this actually dealt with a recap I wanted to provide for the cross-examination and the qualifying questions. The process is the kind of summary in short. In addition to qualifying who they are and what their experience is, when your expert is qualifying themselves, what they need to provide is what knowledge base they have, whether it be a college degree or they are, the dance leader or head dance person or cultural leader or tribal elder, whatever the knowledge base they have to form their opinion, that's what they're going to respond to and answer. The cross-examination, the relevance, so if you're making an objection with the relevance of that cross-examination relates directly to what the person responded to as their qualifications. So it's kind of when we talk about evidence, we talk about opening the door. Have we shut that door and kept it closed, or did we open it up? And once we open it up, then your witness has to be prepared. And the redirect is similar to that. And I think that's, Mark, what you're talking about is the timeline. If it doesn't come up, if you're qualified as a witness and it doesn't come up about your history, and then the other side doesn't like what you're saying and they try to bring your history in and it had nothing to do with your qualifications, you might be able to argue that it's more prejudicial than probative. So if it didn't come up before, that's where that might come in as an objection you can make to protect your expert witness or yourself. Was that a fairly accurate recap? Okay. I'm checking all the lawyers because I'm just a recap person. I am not an expert in this field. Were there any other questions?
Okay, so
Are we good? Do people feel a little more comfortable about what it takes to qualify an expert in testimony, what the cross-examination looks like in the redirect? The most important thing here is no matter what skeletons or non-skeletons your expert might have, is make sure they understand what they're prepared for. You can try and protect them as much as possible, but it doesn't mean those questions won't be asked. And that's part of being an expert witness. But as you said, you know, if you're counseling people and you're an expert on it, you've dealt with it. So it's just a matter of being prepared to be comfortable about responding to that. Do we have written questions? Okay, we have some written questions coming.
okay. In the meantime, I do want to just make a statement. The best way to really prepare someone for cross-examination, direct examination, testifying in court is to practice, which means really sitting down with the person that is going to be the qualified expert witness, or if you are the qualified witness, sitting down with the person that's going to be asking you those direct questions and going through each of them and answering them out loud to get a sense of what it's going to feel like for you to give those verbal answers out loud. And it's a good way to practice for court. So I really recommend that a witness doesn't just get onto the stand and start answering questions. I highly, highly recommend that there's a practice session that happens beforehand. It's better for the witness, and it's better, you get a better testimony in the end, because the person, hopefully they won't be as nervous, first of all, because they'll know what to expect. And then also it'll give them that chance to see, you know, do I want to answer all these questions, and can I answer all these questions? And is there anything that, you know, I need to go back and maybe research some more so that I can answer these questions properly in court? So I would say practice in advance and practice early enough that if, you know, one of the questions you ask your qualified expert witness is, so did you conduct any interviews in this case in order to prepare your testimony? And the person says, no, I just read the reports from the agency. You can say, wait, what? You were supposed to go and do some research. And that, you know, then you'll have time for that person to correct that mistake and correct it in time for court. So that would be my big recommendation, is practice in advance what those questions are going to be and how it's going to feel to answer them on the stand. And then also I would prepare that written report and review that in advance of the testimony. And we're going to have an exercise where we talk about what goes into the written declaration for an expert witness. But first, let's hear your questions. Stephanie?
So the question we have is, let's say you are disqualified as serving as an expert witness. So you've been retained, you go to court during the cross-examination, the court doesn't find that you're qualified to serve as an expert witness in that case. Does that mean that you cannot be an expert witness in a different case in the future? Are you no longer qualified to be or worthy of qualified expert witness status?
Okay, I will give you the classic lawyer answer, which is it depends. And that really is the lawyer answer and the honest answer, because it depends on why were you disqualified as an expert witness. If, you know, there could be some circumstances where you were disqualified for something that's, you know, such a big issue that you could never serve as an expert witness in any case ever. But most likely, like I said, these qualified expert witnesses are supposed to be qualified on a case-by-case basis. So if you've been disqualified on one case, that really should only matter for that one case. Something I can think of that might disqualify a person for multiple cases, it's hard to say every single case, but for more than just one case, would be if they were disqualified because of bias. That one is probably going to be the toughest challenge to overcome. So if the qualified expert witness was disqualified because, say, they didn't have the required knowledge of the child's tribe's customs and traditions around families and child rearing, that could be overcome in another case where it's a different tribe and the person has different knowledge about that tribe. But if the person's disqualified because they're shown to be biased against, let's say, Indian children and families, that's going to be a lot tougher to overcome in the next case and in the next case. So it really does depend on what happened that made this person to be disqualified. Is there any follow-up on that one? I want to make sure that I've answered that question because that's a really important question.
I actually have a follow-up, Christine. So you mentioned if someone's disqualified for bias,
Okay.
and you also gave examples of some bias questions might be based on this person has only ever provided, I'm going to switch it, you said the county, but say the tribe has a qualified expert witness that they always use, and they've always come up on the side of the tribe as a qualified expert witness. If they're disqualified for bias on that, I'm assuming it might, that disqualification could be used in other cases in the future to disqualify them for bias if the tribe tries to use them again. That's the first part of the question, yes or no, and then the second part of the question is there any way to get past that?
So the first part of the question is, yeah, I stand by my original statement that bias is going to be the toughest thing to overcome. I think once it's been established that a witness is biased, then, if I was an attorney and I didn't want to have that witness testify, I would certainly bring that up in every case. So bias, I think, is going to be the trickiest one. And can it be overcome? Everything can be overcome. Like I said, each case is a separate case, and each qualified expert witness is supposed to be qualified on a case-by-case basis. So in the next case, I think that, to take your example, the tribe could assert this is a different case, and this person was shown to have bias for these specific reasons in that case, but here's why this case is different, and here's here's a showing that this person isn't just isn't just testifying to what the tribe asks, but they're actually doing an independent job when they create their testimony. So it can be overcome, but I will caution, I think bias is going to be the trickiest thing to overcome, because preparation, I think you can say, well, we prepared better this time, and even knowledge, you can say, well, I didn't have the knowledge in that case, but this is a different tribe, I have the knowledge in this case. Bias is tougher.
Are there any other questions or comments?
So I don't know how it would happen that one court would know anything about another dependency because the cases are confidential, and in order to introduce or even talk about any documents or statements, you'd have to bring a motion to disclose that. I just don't see practically speaking how it would ever happen. There's not a database of experts and testimony, and there's no way that anybody, short of asking them, have you ever been in a case where the court disallowed your testimony? I just don't see a practical way that would happen. I do wonder, though, what your thoughts are on the procedure, the process. If a judge says you're not qualified, what happens then? Does the court dismiss the case? Does the court adjourn the case? Do they get an extra time to get another witness? What would happen at that moment in time if a court made a finding that someone, the only expert, was not qualified? That's my question.
Well, that's a great question. And, there's, what do I think happens and what do I think should happen? I think procedurally what needs to happen is the case really can't continue along the agency's representation. Oh, look, my color scheme is okay. Okay, so basically at that point, if the witness has not been qualified as the expert, they can't be qualified as an expert witness. That means that the agency hasn't met their burden for the court to order foster care or termination of parental rights. And so then the court really cannot and should not order foster care or parental rights. So what does that mean in terms of, the practical side? Is the child then returned to the family? I think, again, it's going to depend. It's going to depend on why this witness wasn't qualified as an expert. But, it's so not having that expert may not be enough for the court to say, all right, you didn't meet your burden, case dismissed. What I think is more likely to happen is the judge is going to say, we're continuing this hearing, and you have, whatever it is, 30 days to find another expert witness that can be qualified. But does anyone have any practical experience on what actually happens? I mean, theoretically, yes, the case could end, and the judge could say, you haven't met your burden, I'm not ordering foster care, we're beyond all the deadlines, the child's being returned. But I've never seen that happen in court. It doesn't mean it hasn't happened. I just never saw it in my practice. So, either of the MARC attorneys, or are there any other, witnesses or tribal representatives, have you ever seen that happen? And what did the court actually do?
Okay, we've had a never happened. Has anyone ever seen that happen? Okay.
Yes,
Oh, great.
I was challenged by a defense attorney at one time. I'm sorry, my name is Betty Nez. I work with the Pueblo of Zuni in New Mexico. It's like a 2.5-hour drive west of Albuquerque, New Mexico. And I was asked to be an expert witness in one of the cases, and I'm an enrolled Navajo and work for the Pueblo of Zuni, so they're two different tribes. And at the ICWA court hearing, the defense attorney tried to disqualify me because it involved a Zuni child, and I'm an enrolled Navajo. So that was just two different tribes, and that's what I experienced. She raked me over the coals because I was not from Zuni, and I didn't know how to speak Zuni, and she tried to use customary just to disqualify me. So that was a real experience. But the judge said, no, she's still going to be our expert witness. So that was a positive side. So it's good, when the judges understand who can be qualified as an expert witness. And, just how many times the ICWA representative can be able to testify in court. So those are just all, it's always good to know the judges, the work that you have to do representing the agencies. So that was my experience. Just some of the questions that she asked me, I just couldn't believe what she was asking me. So, but I just thought I'd just make that a comment. Thank you.
Thank you for sharing that. So in your case, you weren't disqualified. They tried, but they weren't able to disqualify you. Has anybody experienced where there's a qualified expert witness at the trial and they are disqualified? Interesting.
Well, I've had a case where someone was disqualified. But like I said, what happened was that the county was granted a continuance to secure a different expert. So that wasn't it wasn't a termination of parental rights. It was earlier in the case at the foster care placement level. So that's the only direct experience I've had with disqualifying an expert. I think it's difficult to disqualify an expert, really. I've not heard a lot of stories about it happening, to tell you the truth. But I did think the comments from the previous speaker. And I apologize, I just can't see any of you, so I don't know who is speaking all the time. But I agree. Thank you for sharing those comments. And it did make me think of one other thing I wanted to stress, which is cross-examination is, I put opposing side and then in parentheses with an S, because that can be, everyone in the court can cross-examine the expert witness. And it really, I've never been the expert witness in a case, but I've got to imagine it can really be unnerving and kind of grueling at times. So I think it's good that you brought that up, that it wasn't the agency, if I understood you correctly, that was seeking to disqualify you. It was actually one of the parents' attorneys. And, that makes a lot of sense to me, because the parents, they don't want that finding in the court that the evidence, the burden of evidence has been met, right? If they can keep that evidence from being met, then that's going to, at a minimum, delay the case, which, parents a lot of times are really desperate to delay cases as long as they can, so that they can try to change their circumstances in the case. So I think that was a really important comment.
Are there any other?
So it is interesting, no one's got a story about.
Yeah, the disqualified expert. Are there
Yeah.
any statistics on how many cases have qualified expert witnesses? Sorry.
Well, every case, if it goes forward, needs to have a qualified expert witness if it's got an Indian child involved. So.
Okay, so it doesn't look like we have any other questions or comments. Does anybody else have any experiences they want to share? Okay. All right.
Okay. So we're going to just move on, and this is sort of our wrap-up slide, which is qualified expert witnesses, what are the best practices? And, hopefully we've clarified what the legal requirements really are. But I think both through the presentation and also through the questions and the discussion, we've been able to identify, beyond those minimum legal requirements, what are some best practices around qualified expert witnesses. One is, and it depends on if you're a tribe or an agency really, but if you're representing a tribe or maybe even an Indian parent, it could be considered a best practice to request or make a motion or object if that court doesn't have that expert witness testimony at the detention level. So I know that's not really what's happening in a lot of the cases right now. So that could be something that becomes a best practice for tribes, is to ask that courts require expert witness testimony as soon as a physical removal happens, rather than just at the point that California considers the legal foster care placement, which is at the disposition hearing. Another best practice that we've identified is to try to secure someone to serve as your expert witness that isn't the tribal representative or the tribal social worker. And we talked about why that can be problematic. So if possible, if you can get someone other than that tribal social worker or ICWA representative, then that's going to have potentially a better outcome for your case and for the testimony. Some other best practices, get a written contract of whether you're securing the expert or you're going to be the expert. I think it's best practice to have some kind of written contract that lays out compensation, that lays out what the expectations are for preparation, and then what to do if in the end of your research you don't feel you can provide the testimony because you don't agree with the agency recommendations or the tribe's recommendations. And then finally, something around confidentiality, agreeing to keep that information confidential and not discuss it during or after the case with anyone outside of the parties. And We also talked about preparing for the case. It's going to be best practice to not only review all the documents in the court file, but you want to review the case log, the service log from the social services provider or agency or social worker. And you also want to conduct your own interviews, preferably in person, if and whenever possible. And then I also recommend, as a best practice, creating some sort of written document that records what your testimony is going to be in court. So everything from your qualifications to all of that research that you did, write it all down, and you can put it into the form of a declaration, you can put it into a report, but just the way tribal social workers and county social workers should document all of their efforts on a case, you should document all of your efforts as an expert witness to prepare your testimony for the case. And then I would say finally, best practice is to practice your testimony, practice going over the questions that you're going to be asked, and if possible, even do some real role play practicing, asking some tough questions and how you're going to handle those on the stand, so that you do maintain your composure and you can still be taken seriously by everyone in the court. Because as an expert witness, your testimony is vital to the outcomes of these cases. Are there any other best practices that came out of today, or that some of you might have based on your experience that we can discuss in the group? And if anyone has any, I again cannot hear.
We don't have any yet. I had a question, this is Stephanie.
Hello.
Hello. So I'm realizing that, just from my talking to people, that it's very difficult, and I already knew this, but it's very difficult to find a qualified expert witness that is a tribal member of the tribe for various reasons. Not to mention which, some of the political issues, family politics, and also the uncomfortableness with being on the stand. Is there any, and we heard one example, if it's difficult to find a expert witness from your tribe, maybe a tribe nearby that's familiar with your tribe. So they don't have the same family connection, but they're another Native American tribe, California Indian tribe, or other state tribe that is familiar. So the example was Navajo versus Zuni. So that might help with the political issues. Other than going outside of the tribe and looking for folks with similar cultures or similar family values or similar knowledge base, are there other suggestions on how to address finding a qualified expert witness when it is difficult to find one from the community? Like, who have you seen that have been effective?
Yes, well, so one suggestion that I have is that if you are having trouble securing an expert witness, and I do believe it can be challenging to find someone from the child's tribe, whether the tribe is small or large, there may just be sort of a conflict within other tribal members' belief system about coming into court and testifying that this fellow tribal member is not capable of parenting their children, whether it's true or not. So if you are having difficulty finding a tribal member of the child's tribe, then one resource that I know of that is updated on a regular basis is offered through the Administrative Office of the Courts. They have a tribal projects unit, and online they maintain a list of names of people who are willing to serve as qualified expert witnesses in cases in California. I want to clarify, this list is not an endorsement, so it's not as though the Administrative Office of the Courts is saying that these are good expert witnesses. It's just that these are people who have submitted their name to be included in the list. So you know that everyone on the list is willing to be an expert witness and go into court and testify. So that can be a place to start if you're having difficulty finding someone. Also, in the California Rules of Court, it says that if you are looking for a qualified expert witness and you're the county, you can approach the child's tribe to ask for help in identifying an expert witness, or you can contact the Bureau of Indian Affairs. I don't know of anyone that's relied on the Bureau of Indian Affairs to get contact information for an expert witness, but in theory, they would have a lot of names. So those are specifically mentioned in the California Rules of Court, and also I think in the Welfare and Institutions Code. Another practice that I know of, one tribe has done, it's a tribe that I work with, is they actually had a training on being a qualified expert witness, and they went and recruited tribal members to come and learn about what does it take to be a qualified expert witness? Is it something you could do? What is it like? And then did sort of a mock trial to let the people in the audience see what would be expected of them. So they basically tried to recruit and train people from the tribe because they were having trouble in cases involving their own tribal members where there weren't any tribal members coming forward to be expert witnesses. So the tribe decided on their own, well, maybe this is something we wanted to address with our community and see if there's people in our community who could serve in this role and who would be comfortable serving in this role. So those are just some of the things that I've seen happening or can recommend when you're looking to identify a qualified expert witness, and either trying to stay within the community or trying to go outside of the specific tribe, but stay with someone that's got that expertise in child rearing for the tribe.
Two clarifying questions, Christine. It's Stephanie. So one, I'm assuming that if anyone here wants to do a training in their community or their tribe to qualify some expert witnesses, I would feel comfortable them using portions of this training to explain to folks what would work, what you should be expecting, how it would be done. And for those of you that have actually experienced cross-examination, you should be the opposing side's cross-examiner. Is there anything that we didn't include today that we can just let people know now if they want to take some portions of this online training when it becomes an online training to qualify their community members as qualified expert witnesses?
No, I think the only thing we didn't really touch on that we've it's not in the slides, but I think we covered it a bit through the discussion, is just to let community members know, if they're not someone who works in a capacity of providing counseling, direct services, or social work to people, they may not, really be prepared for what's going to happen in court and what kind of questions will be asked of them. So that would be the only slide I would want to add is, if you've never been in a court or you've never been asked, really direct questions about your knowledge, who you are, where you fit in the community, that, you should just be prepared that is something that could happen when you provide your expert witness testimony. And then you may even want to talk about how this could affect your day-to-day life in the community, because there may be people that aren't happy with you, that you did go and provide this service in court. So that would be slides I would probably include. But otherwise, I think this would be a great training tool for that purpose.
And then that really wasn't a plug. I really was trying to make sure that this is a useful tool for you guys, I promise. The other question I had was, and let Christine answer if this will work. When you were talking, I was thinking of one way to address the issue of difficulty finding tribal members to be expert witnesses is you might be able to find a cadre of tribal elders or community members that are willing to be the resource for the qualified expert witness. So for example, you might be able to go on the AOC list of experts, of people who have the expertise or specialized education to be an expert witness, and you give them access or you help them interview tribal members, tribal elders, who can help them get a better idea of tribal customs, customary practices, so that your tribal members are kind of insulated from having to be on the stand, but that important component of the qualified expert witness testimony is what is developed by those I guess, professional expert witnesses, so to speak. It's not as ideal as we had the list, but that could be something that tribes could do as well, right, Christine?
Oh, yes, I agree. Yes.
So another best practice we are recommending, or we can recommend, is if you have a lot of tribal elders or tribal community members who do want to help, they do want to provide that kind of information on what would be needed, they can be there as a resource for someone who's more experienced or more comfortable dealing with the cross-examination, or maybe doesn't have community skeleton in the closet that can be used to the disadvantage of the case, that they can just take the relevant research and information.
Yes, and I think a way that can be done is something that I haven't done for qualified expert witnesses, but as a judge for a tribe, I had a case where the question of a tribal law or custom, if you will, was brought up, and rather than have someone come in and testify as to who was right or wrong in the case, I simply asked the group of tribal elders for their opinion on the law. So all they were asked to do was tell me what is the custom around this particular law that applies to this case. Not who's right and who's wrong, just what's the law. So I definitely think that a group of community elders, leaders, healers, spiritual healers could provide information about what are the tribal customs and traditions that surround child rearing for our tribe. And then someone else could take that information and go and provide the actual necessary testimony around. And so based on this, it's my opinion that this removal is either appropriate or not.
And full disclosure, because the expert witness is the one who comes up with the opinion, your tribal elders can't tell the expert, so this is what you should say because I'm not going to be an expert witness. The professional
Right.
expert witness could come up with a different opinion. So, I mean, they could take it and not necessarily agree with the same opinion that your tribal member would have, but at least if you can't get a tribal member feeling comfortable enough to testify, at least you can try and pull in some of those family values and standards, customary practices. But there is always the possibility that the person hired just doesn't interpret that the correct way.
Right.
This is Mark again. Can you hear me, Christine? No?
Barely.
Can you hear me now?
It's a little better. I heard you
How-
really well.
All right, well, I'll talk to myself, and if you catch it, let me know. My advice my recommendation as a practice point on declarations, they aren't ideal to let the declaration be the substance and the entirety of testimony, but it's not a bad thing. If you're actually litigating a case and the other side gives you their declaration in time, that will give you an opportunity to decide, because I have an advocate's hat. I'm not really neutral. That will give you a chance to see what their opinion is and decide if you want to have a countervailing opinion. So you need to get the court to give you that opinion early enough so that you can find a different opinion. That said, you can't ask someone to give you an opinion. You can't ask them to have an opinion and you'll pay for it. So many times lawyers will have experts give them an oral opinion first. They won't have it committed to writing, because if it's in writing, it's discoverable. Find out what the other side has to say, and then do the things Christine's suggesting, which is get your pool and put your ducks in a row. And one of the things that an expert can rely on is another expert's opinion. That's perfectly fair game. So you can show them the other opinion and ask them if they disagree with it and why, and what things they considered that were not considered in that opinion. Then you've done your job, and you just have to have enough time to do it.
And Mark, correct me if I rephrase it. So it sounds like the recommendation you're doing is because anything written and developed for the case can be discoverable by the other side, and the other side could take a written declaration and then find an opinion to have a battle of the experts with that opinion. It's a good practice to first get an oral testimony from your expert, have a conversation with them to make sure that their opinion is what you need or want, and then work it out before you do the written declaration. Is that? Yeah. It's best if you have an advocate, but if you don't have an advocate, one thing the advocate would do that you might not do is get the expert opinion in orally before you have them write it down, because if it doesn't fit with what you're trying to do, you might not want it in writing. So that's something an advocate would do that, say, like a tribal social worker might not think to do. So that's a really good practice point. Anything to add to that, Christine?
No.
All right, so is there any other questions or comments with that now? All right, we're going to move on to the exercise. It's all you, Christine.
Okay, great. So, I forgot about this. I just wanted to make everyone aware before we move on to our exercise. There is an all-county letter that was put out by the California Department of Social Services that does directly address the use of a expert witness in the Indian Child Welfare Act. And so whether you like it or hate it, here it is. It's all county information notice number, I guess that's a 1-40, or is that an I? I think it's I-40-10. And we've included it here just so that you have it, but you can also find this online if you go to this little website here, www.cdss.ca.gov. And it doesn't say anything too different from what we've talked about today. So, feel free to read it. It's a good refresher. And it also tells you what the California Department of Social Services interpretation is going to be about the use of a qualified expert witness. So it should be in your materials. Again, you can go online and check it out. So hopefully everyone can see this document here. And this is just a sample declaration that I prepared that will hopefully help you all in thinking about what you want to include into a declaration or a report. So we talked about, Stephanie, taking some time. I don't know how much time you want to allow, and have everyone in the audience write down sort of the key components that you want to have in your report, and then we could go through this declaration and compare based on what you've included and what we have here. But I don't know if we're getting a little tight on time, if we should maybe just go through each part of the declaration. What did you think, Stephanie, in terms of how to proceed?
I think it might, why don't we just take 5 minutes, just like top of your head, what you would think to put in a declaration, and then we'll go over it. So we won't allow a lot of time, but I think it's good for you guys as a learning practice to just think, okay, if I'm preparing my expert witness's testimony or going through a declaration or writing it, what are the things I think need to be in that based on what we've discussed? Just use, like I said, it's not great, just use the pads you've got in front of you to just jot down a couple ideas, and then we'll go through what's required, and then you can kind of compare with what you wrote down versus what would be needed.
All right, so this is, like I said, just a blank sample declaration. And if you don't have access to, this is called pleading paper. Pleading paper is this paper that has these little numbers on the side here, the 1 and the 2, and there's actually specific requirements for every paper that gets filed into state court. And so if you want to have your declaration filed in the court, or you want your expert witness's declaration to be able to be filed in the court, you should follow the proper court format. So this declarations example does follow that court format. And I just used here the county of San Diego, again, because, you know, we're in San Diego today. So you obviously want to put in whatever county you're in. Here we've got your name, the street address, city, zip code. If you have an attorney that's representing the side that you're, you know, that you're working for, then you want to put that, your attorney's name in there. But you may not have that information, so just, you know, put in your information. And then this is just the format for the way the case is sort of introduced at the beginning of a document. It's gonna be, you know, in the matter of, and sometimes it has in re the matter of, and then it has the name of the minor child or children, and then underneath it it'll say minors. And then over here, you're going to want to fill in the case number, and every court assigns every case a number. So you'll have to, again, get that from the parties in the case. And then it'll be called declaration of, and your name, the expert witness name. And then you'll put a comma, and that's the qualified expert witness. You can put the word ICWA in there if you think it's helpful, but the main thing is to have declaration of and the expert witness's name. All of this information here is, if you have it, then include it. And if you don't, then it's okay. But it does help the court clerk, when you file it, get it to the right file and make sure the judge sees it in time for the hearing. But like I said, you may not have that information. So if you can't fill that in, that's okay. Oops. Oh, these things stay on the screen. Oh, it's so fun. I've never used the pen before. I like it. Okay, so moving down here, this is how, you know, a typical declaration is going to start. And then you have your name. I'm over the age of 18, and I know the following facts of my own true knowledge, except for those facts based on information and belief. And that's just sort of standard legal terms for starting off a declaration. And if called upon to do so, could and would competently testify thereto as follows. So you're basically saying everything else I'm about to include here, I either know from my own true knowledge, or I have that information based on information and belief, and that I could testify to all the stuff I'm about to say. So I broke it into, I think it's 3 parts. Let's see if that's right. Maybe it's only 2 parts. I think it's 3. So the first part is going to be qualifications of the witness. And you don't have to include, you know, these part 1 and this employment information, the things that are in brackets. You don't have to necessarily include those. But I wanted to put them in so you could see the way that a declaration can be organized, that the court will be most used to, that would probably be most effective for delivering, you know, your testimony that you're trying to get across. So you can start with employment information. You know, I am employed by, previously I worked for, and, you know, you can go on from there. But you want to make, you know, each statement a separate number, so that it's easy for the court to read and it's easy for the other parties to read. And so these could end up being, you know, several pages if you get someone that's got a lot of experience. Training and education. So if you do have special training or education, or your expert witness has special training and education, you want to include that. I graduated with a degree in blank in 2001, whatever year it was. I completed the following training programs. And then some people may have experience delivering education and training. So I am a certified trainer for whatever it is, parenting classes, and provide those. So education and training there. And again, these are just short examples. You want to include as much as you can about all of this. Practical experience relating to the case. So for this one, I'm familiar with the child's tribal community because I, and these are just examples, have lived in the community since a certain date. Because I am a member of the child's tribe. Because I am considered an expert in the child rearing practices of the child's tribe by the child's tribal community. Because I am a professional psychiatrist and an expert in the field of child development. Whatever it may be, this is where you're going to put in your practical qualifications that make you an expert in this particular case. And again, these are just a few examples that you can use. Here we have part 2, research done by the witness to prepare their testimony. So you're going to want to list and describe the documents that you reviewed. And again, this could be a lot of documents, but if you reviewed it and you're relying on it for your testimony, you want to list it in your declaration. So I have thoroughly reviewed the following documents. 1, or A, I guess I put A. Name of county social worker. So, social worker Susan Wells. Service log for this case, dated, and you want to include some kind of date that identify the service log. So maybe the beginning date and the ending date. Something that shows what you were looking at. Another thing is all the reports filed by let's say the county in this case. And then it is best to list each report that you're relying on, if you can. And then all the reports filed by the tribe in this case. And again, it's best to list each one. And just on this note, I'm going to use the highlighter again, just, because it's fun. Reports filed by the tribe. I do not see reports filed by the tribe often enough. I wish that tribes would file reports in the cases where they're intervening as a party or monitoring, just so that there's that written report on the record in case it goes to appeal, or even when you need an expert witness and you want to have something for them to review. I think that it's a really great way to get evidence into the record. And so if the tribe has a way to file reports, I think they should do that. And if there aren't any reports filed by the tribe, then the expert witness should look at those and should tell us which ones they have seen. List and describe all the people that the expert witness interviewed. So I have interviewed the following people in person. List all the family members, tribal and county social workers, service providers, or anyone else that you interviewed in person. Include the name of the person interviewed, the date the interview took place, and the location of the interview. And then you're going to do the same thing for this one, except this is going to be people you interviewed by telephone. List all the same people, family members, tribal, social workers, county social workers, service providers, anyone else that you were able to interview, you were not able to interview in person, but you were able to speak to over the phone. And again, just include those person's name, the date that the interview took place, and the location of the interview, meaning where you were when you were calling that person on the phone and where you were told they were. You may also want to include why they were interviewed in person, but that may not be relevant. So you may not want to include that. But I would make two separate lists just to keep it clear, or at least if you have one list of interviewed people, note by each name, was this interview in person or over the phone? So next, you're going to want to list and describe all the evidence that you learned from your research. So this is, again, this could be long. And this, your declaration could end up being several pages long. So you're going to want to include things like, on a certain date, minor was admitted to the hospital with injuries as follows. On another date, county social services removed the minor and placed him or her in emergency foster care. Mother and father do or do not live together in the home. Mother is a tribal member, or father is a tribal member. One of them is most likely a tribal member. This is an ICWA case. Or both. Let's see. Mother had physical custody on the date the minor was injured. Mother provides the following explanation of the minor's injuries. And then you can include mother's explanation is or is not consistent with the child rearing practices of the minor's tribe. Again, this is just a made-up example. You're going to have to tailor this to what's happened in the case that you're reviewing, or that your expert witness is reviewing. So this is going to be kind of the summary of all the documents you reviewed, all the interviews you conducted, put into one nice list so that everyone can see what you're basing your opinion on. And then finally, and this is the most, should really be part 3, but I need to fix that. You're going to state your opinion of the proposed action, the removal, out-of-home placement, termination of parental rights. And so, you can use this exact language here or some kind of paraphrasing of this first part of the sentence, but based on my qualifications stated above and all the evidence I have reviewed as stated above, it is my opinion that continued, in this bold italic part, this is the critical part, continued custody by the parents or Indian custodian, if it's a case involving removal from an Indian custodian, and again, is or is not likely to result in serious emotional or physical damage to the child. And then from there, you can go on to further qualify that, especially if you feel there are some sort of specific tribal customs and traditions that really back up your opinion. But if not, this is the critical language here. The continued custody by the parents is or is not likely to result in serious emotional or physical damage to the child. And then this is, again, the standard closing for most declarations. I declare under penalty of perjury under the laws of the United States that the foregoing is true and correct. And you want to date it and then put your name. Actually, it doesn't need to say in pro per there, but now it's gone. So you're going to want to put your name and then sign it. And that will be the closing of your declaration. So like I said, this is just an example, and there's going to be a lot more information. It's probably going to be a lot longer, but it sort of gives you an idea of the format that you want to use if you want to have this declaration filed in court and considered by the other parties. So was there anything that anyone included that we didn't touch on here that you put in your list when you were creating your sort of 5-minute declaration? Or does anyone have any questions?
Did anybody include something that she didn't have in there or thought that should be in the declaration? And are there any questions about that? Now remember, this is the written declaration. The testimony should be live, but you would also file something like this as a written record of the testimony that's going to be provided by the witness. And as Mark pointed out, you might want to talk to the witness first, figure out what they were going to put in the report before they write it up and file it with the court. Christine, was there anything else we wanted to go over with folks? Does anybody have?
No,
any
I don't
questions?
think so. I think that this is sort of the declaration that if you do think you can reach agreement with the parties to not have that live testimony, this is going to be the beginning of that. I think parties are going to want to see something first, and then based on what, the declaration says, it's usually after seeing the declaration that all the parties are able to reach an agreement. And from what I understand, that does happen. There are times where an agency or a tribe will send around a declaration and everybody says, yeah, that looks good to me. And everyone signs the stipulation and moves on to the next part of the case. So, but I think Mark, I think it was Mark Radoff that raised this point. This is something that, once it's filed with the court, it is public record and it's going to be out there. So before you get this information in writing, if you are the person who is seeking to get this expert witness testimony from someone else, you may just want to check in with them first before they prepare their declaration and ask them, what were your conclusions after you did your research? But I think this is a pretty good format to start with, to look at, how do you get all that information and conclusions onto a paper that people will recognize and use in the case. Well, I wanted, before we mute and everything, I just wanted to thank everyone for coming, and I hope that everyone learned something today. And as Stephanie said, please be liberal with your comments so we can make improvements for the next training and for this type of training. And again, thank you all for your time, and thank you for your dedication to Indian children and families. I appreciate it. Signing off.